Hello and welcome. Today, we're breaking down two important employee leave laws that every California employer should understand: the Federal Family and Medical Leave Act, or FMLA, and the California Family Rights Act, known as CFRA. If you're a small to mid-sized business owner, office manager, or HR administrator, understanding how these two laws compare and how they overlap is critical for staying compliant and avoiding costly mistakes. Let's start with the big picture. Both FMLA and CFRA provide job-protected, unpaid leave for eligible employees who need time off for family or medical reasons. In most cases, each law allows up to 12 weeks of protected leave in a 12-month period, and both require employers to continue group health benefits during the leave. However, despite these similarities, there are key differences, and those differences matter, especially in California. First, let's talk about employer coverage. Under FMLA, the law applies only to employers with 50 or more employees within a 75-mile radius of the employee's worksite. CFRA, on the other hand, applies to much smaller employers. If your business has 5 or more employees anywhere, CFRA likely applies, even if you don't meet the federal FMLA threshold. This means many California employers who are not covered by FMLA are still required to comply with CFRA. Next, let's look at employee eligibility. Under both laws, employees must have worked for the employer for at least 12 months and have worked 1,250 hours in the 12 months before the leave begins. However, FMLA adds an additional requirement. The employee must work at a location where the employer has at least 50 employees within 75 miles. CFRA does not have this geographic requirement, which again makes it broader and more applicable to smaller or distributed workplaces. Now let's discuss what types of leave are covered. Both FMLA and CFRA generally cover leave for an employee's own serious health condition, caring for a family member with a serious health condition, or bonding with a new child through birth, adoption, or foster placement. But here's where we start to see important differences. Family member definitions under CFRA are broader than under FMLA. FMLA covers care for a spouse, child, or parent. CFRA expands this list to include domestic partners, siblings, grandparents, and grandchildren, and in some cases, a designated person. This means an employee may qualify for CFRA leave even when FMLA does not apply. Another important difference involves pregnancy. Under FMLA, pregnancy and pregnancy-related conditions are treated as a serious health condition. Under CFRA, pregnancy itself is generally not covered. Instead, California uses a separate law called Pregnancy Disability Leave, or PDL, which can provide up to 4 months of job-protected leave. After pregnancy disability leave ends, an employee may still be eligible for up to 12 additional weeks of CFRA leave for baby bonding. This often results in more total protected leave for California employees. Now let's talk about concurrent leave. When an employee qualifies for both FMLA and CFRA for the same reason, the leaves usually run concurrently. However, because CFRA covers more family relationships, there are situations where CFRA leave does not run concurrently with FMLA. For example, caring for a sibling may use CFRA leave only. This is why accurate leave designation and tracking are so important. Accurate record-keeping prevents extended leave obligations or legal claims. Next, let's cover employer responsibilities. To stay compliant, employers should focus on a few key best practices. First, clear policies. Your employee handbook should clearly explain CFRA and FMLA eligibility, how leave is requested, whether leave runs concurrently, and how benefits are handled. Second, required notices. Both state and federal law require employers to post notices and provide written information when leave is designated. Third, accurate record keeping. Track hours worked, leave taken, and how leave is designated. Mistakes can lead to legal claims. And finally, manager training. Supervisors should know how to recognize a leave request and understand that retaliation is strictly prohibited. It's also important to remember that CFRA and FMLA provide job protection, not pay. Employees may get wage replacement through programs like paid family leave. So, what's the takeaway? For California employers, CFRA applies to more businesses than FMLA and covers a broader definition of family. Pregnancy leave is handled differently under California law, and proper tracking and policy clarity are essential. If you're unsure or if your policies haven't been updated, it's a good idea to seek professional HR guidance. Visit kphr.com to connect with a professional today. Thanks for watching.